Hello, everybody, and welcome to week 4 of Civil Rights and Civil Liberties Online. Hi, everybody, and welcome to week 4 of Civil Rights and Civil Liberties. And this week, we're going to be looking at the rights of African Americans and very briefly other marginalized groups. And we'll also be looking at part 1 of the rights of the criminally accused. And if you're wondering why I put these two topics together, I'll be getting to that in a little bit. So, for this week's agenda, just remember that your individual project is due on August 12th. Don't let those due dates sneak up on you. I'm also letting you know, if you didn't already read it, that the Classroom Constitution was posted to the announcements page and it was emailed to you a few days ago. And also a reminder that I'm available during my office hours and by text and email if you have any questions. So don't feel like you cannot reach out and ask anything, like, if a question doesn't make sense or something to you. And you can see the first page of the syllabus for all those details, like the link to my office hours and my Google Voice number for texting, email, everything like that. Another thing I wanted to touch on is one student did ask me if they suggested that I would have you do your readings before watching the video or after. It depends. If I didn't have any background on a particular topic, I would probably watch the video first. And if I did already have a background in a certain area, I would watch the video first and then maybe look at the readings after. And what I mean by background is, sometimes people had a real big interest on something that they learned about in high school, and you might have taken a deep dive, how we all kind of click around online. Then if something interests you, the next thing you know, you're 10 videos deep and learning a lot about some subtopic. So that's what I mean by background knowledge. Or maybe you've read some great books. So as far as why we're covering the two topics during the same week, well, there's one practical reason. It's that I have to cover a lot each week because it's a 6-week course. So there's the practical reason. But as we'll talk about more during this week's video lecture, that the rights of the criminally accused isn't really a topic that is unrelated to the rights of African Americans. In other words, there are some schools of thought that believe that we historically started having a huge wave of formalized police departments because of certain economic realities that became apparent after the Civil War and after the Emancipation Proclamation and the post-Civil War amendments, mainly the 13th and 15th Amendments. But we'll talk about that in a bit, and hopefully it'll make sense. So, one thing I want to do is give some context, some historical context, because I don't expect everybody just to remember every chapter of U.S. history that they had in high school. So just to give some historical context to some of these older cases we'll be looking at, we're going to start first off with discussing the topic of African Americans and when slavery actually started. And what you'll hear a lot, and there's almost a consensus among historians, or there was a consensus, that our beginning point is 1619, because you'll see that famous quote there. You probably heard it before. John Rolfe noted in a letter in 1619 that 20 and odd Negroes were brought by a Dutch ship to the nascent British colonies, arriving at what is now Fort Hampton, then Point Comfort in Virginia, and then eventually most of them on to Jamestown. But there's really evidence of slavery existing way before that. I mean, certainly globally and historically, going way, way back into the first times of recorded history in Egypt and all over the globe when people would be engaged in warfare. A lot of times the people that lost would be forced into servitude and or slavery. So that's gone on forever. But if we're going to talk about enslaved Africans that are actually, kidnapped and shipped over to this continent, and where we have this, phenomenon of human beings being owned like chattel, that had been part of Portuguese, Spanish, French, and British history all across the Americas since the 16th century, and that's mostly, the early 1500s. So I did include a meme on here. I'm not big on bringing in memes into academic courses, but sometimes they're good for making a point, especially to people who say things like, oh, history was so long ago, why don't you get over it? And they'll be saying that to people that are, expressing concern about current racial issues. But if you look at this meme, look at how far back, slavery actually began on this actual continent. That goes so far back. And then you have periods of segregation, which even my dad remembers when he was in high school. He was a freshman in high school when Brown versus Board of Education was decided. And then look at how recently the post-segregation world has come into play. So just keep that in mind for context and what some people might remember experiencing even firsthand that are maybe your, my parents' age and probably your grandparents' age. Another thing for context is 93 years earlier than what I just mentioned, there were some Spanish explorers who brought 100 slaves with them to a doomed settlement, which is now South Carolina or Georgia, what most people would consider right around, that area, and in the Carolinas. And within weeks of their arrival, those enslaved Africans, they revolted and they managed to take off into the woods. Basically, they vanished. They didn't, the document evidence shows that they didn't, kill their captors. They just escaped, and their captors eventually died of disease. And you have an entire ethnicity of people. If you wanted to look at a copy of this PowerPoint that's linked to the handout section and zoom in, you can see a picture of this family that belongs to what's called a brass ankle family near Summerville, South Carolina. And that is a nickname for an ethnic group that can be somewhat controversial, because think about it, calling people a brass ankle group, why did they get that nickname in the first place? Because they had run from captivity, probably with chains still around their ankle, but it became one of those things where people kind of turned it around and used it as a name of pride to identify their unique group. And they were, or became, modern-day triracial isolate groups. These folks, when their DNA has been tested, they have traces of African ancestry, European ancestry, and also Native American ancestry, because from what they can tell, they took off into the woods and eventually assimilated into society, with some people marrying and having families with Native American people or people that were mixed Native American and white, and also people who were part of the Caucasian economic underclass. So they sort of became their own group. So the reason why I'm bringing this up is things have been around a lot longer than people like to think. And then kind of bringing it up to the time where hopefully you remember just a little bit from high school as far as context. The Emancipation Proclamation was made in 1863, but it was limited in scope and authority, if you remember that, right? There were still some states for structural, political, and economic reasons that still had slavery in spite of that. And the Civil War officially ended in 1865, and the 13th Amendment that banned slavery wasn't passed until later that same year. If you know anything about the Juneteenth celebrations, it wasn't until June of 2 years later that some slave owners in southern states that lived on somewhat isolated plantations ended up informing their enslaved people that they had actually been free for 2 years, or in some cases they found out another way. The 14th Amendment, one of the other main key post-Civil War amendments, it provided protection and citizenship for those born in the U.S. or who were naturalized, including enslaved persons, and got passed in 1868. And it promised equal protection and due process. And then the 15th Amendment was ratified in 1870 and gave formerly enslaved males the right to vote. So despite these post-Civil War amendments, African Americans were faced with black codes, Jim Crow laws, segregation, and violence. So keep in mind also, for context about things you might read on paper, like the Emancipation Proclamation and all these post-Civil War amendments. What was written on paper wasn't exactly reflected in the everyday lives of African Americans at that point in time. And as we'll talk about in a minute, it did reflect the way things were handled in the criminal justice system as well. And just a couple more notes to make about historical things before we get to the first big earth-shattering landmark case that you might remember from high school, is that what we'll talk about when we get to the part where we talk about the rights of the criminally accused, the way the 13th Amendment is worded, which bans slavery, there's an exception in there for people who are currently incarcerated. So that will affect what we talk about later on. And the last thing being, giving us context about how what's put on paper and in the amendments and in the Constitution and what's supposed to be a reality in the everyday lives of African Americans wasn't exactly a reality for a long time. Remember, the Plessy versus Ferguson case was ruled on by the Supreme Court in 1896, not a terribly long time after all these post-Civil War amendments were supposed to guarantee equality for black folks, including formerly enslaved persons. And if you don't recall, Plessy versus Ferguson was the case with the separate railroad cars, where Homer Plessy brought suit because he was forced to ride in the railroad car for colored people only. And when it got up before the Supreme Court, the ruling was separate is equal. There was no violation of equal protection or due process because the railroad company had provided a separate railroad car for him, and that separate was equal, and that was perfectly fine. But fortunately, that changed with the next case we're going to talk about. So now we turn to Brown versus Board of Education, a case that the Supreme Court decided and ruled on in 1954. And most of us are aware of the very basic facts of the case, and that this wasn't just about the Brown family, that it was a combination of cases that arose out of Kansas, South Carolina, Virginia, Delaware, and Washington, D.C., and that these families were suing because the schools were segregated, and the schools that had been set up for African American children were of subpar quality, and it was unfair. And this situation certainly wasn't, meeting the guarantees of the 14th Amendment to provide equal protection for all citizens. But it seemed like a very tough case at first because of the Plessy versus Ferguson case that had been ruled upon that said separate was equal. things could be separate and segregated, and that was all fine and dandy. So the Brown family and their attorneys and all the companion cases, that was the challenge that was in front of them, that the precedent case, the prior case, didn't really support their position. So think about the great challenge that was in front of these families and these attorneys. African American students, they've been denied admittance to certain public schools. The ones that were, certainly the good schools in the area. And they were arguing, obviously violation of their constitutional rights. And the lower courts did not give them the relief that they sought based on Plessy versus Ferguson. And, these lower courts were relying on the separate but equal doctrine. So most of us know when the case went up before the Supreme Court that the Supreme Court said no, separate is not equal, that in the past that was ruled upon as being equal, and that was something that should not have been done, and that it was a flawed theory. And as far as nuts and bolts reality of the schools, if you looked at the actual building itself and the conditions of the building and the credentials of the teachers and, how these schools were heated and proper lighting and desks and books and curriculum, like everything about it was not equal in any way. And that was part of the proof of the case. But one of the significant parts that gets forgotten about, I think sometimes because the overall huge issue of schools being desegregated was so huge, right? That the plaintiffs and their attorneys didn't just show, what any of us could see in pictures from a history book, that these schools were not equal. That's ridiculous. But they also showed the incredible amount of psychological harm that was being done to the students. And one of the main ways they did this was through the doll experiment. So I'm going to show you a little bit of the doll video. The link is right there if it's something you wanted to look at later. But at the time, in the 50s, there were certain protocols in place as far as proving something by research, social science research, and certainly all the parameters of the way this experiment was done would probably need some tweaking to, pass the muster of the standards we have today. But it was something that the Supreme Court mentioned in their decision, and it was pretty consequential because, well, at least to me, and probably to you when you see this, this is just as important as showing the the buildings that the students were in were substandard. The teachers were not as, credentialed. The books weren't as good. The buildings weren't heated as much. This part about psychological harm is so significant and so apparent when you watch this. So I'm going to pause 1 second and pull up the video. All right, what I'm about to play is just a little clip out of a movie, and it's pretty self-explanatory. You'll see that they're asking these young African-American students which doll is better, which doll is prettier, and you'll see they're selecting the white dolls because of all the messaging that they're getting from the segregated society that they're living in back when we had full-blown apartheid here in the United States for quite some time. So I'll let the rest just play on its own.
Hello, Vernon. Sit down. Show me a white doll.
This one.
Now show me a colored doll.
That one.
Show me the doll that you like best.
That one.
And which doll is most like you?
That one.
All right, Anne. Show me a white doll. Show me a colored doll. Show me the doll that has a nice color. Show me the doll that looks ugly.
So the experiment that you just saw from the video clip, that was a recreation of, the actual experiment that was done, and that was some of the data that the court looked at. And coincidentally, there's been recreations of that type of experiment done in recent times, and in a lot of the instances, it shows that colorism is still alive and well in some of the experiments with younger kids of color. They're still choosing the white dolls. But I recently came across one, I think it was in late 2017, that showed that middle school age young African American girls were not choosing the white dolls, which is great news because of course, you don't want young people to internalize certain prejudices that are really prevalent. But in any case, going back to Brown versus Board of Education, one thing a lot of people don't know is that there was a part 2 to this case where, to make a long story short, basically the same fact pattern came up again, but not on the main issues itself. What was being presented to the Supreme Court was basically, logistically, how are we going to do this and how fast do we have to do this? And the Supreme Court basically said, you have to integrate those schools with all deliberate speed. So that meant, get off your behinds and do this right away. So this case was symbolic for 2 huge reasons. The Supreme Court of the United States showed that it can and will overrule itself. In recent history, that was done with the Dobbs case, but it was earth-shattering in 1954 because that was an instance where they were expanding civil rights and human rights. Traditionally, when you hear about the Supreme Court overruling itself, it used to mean that the Supreme Court was taking stock and saying, wait a minute, there's a societal issue that was never addressed correctly, and now we can correct the situation looking through a modern lens. If you're familiar with U.S. history and the Federalist Papers, all the founding fathers said this should be a living, breathing document to grow and change with the times, which, that's something some of the traditionalists do not pay attention to that part of the Federalist Papers as much as other things. The other thing is what came to be known as the Warren Court, which you can see there in quotes, started becoming known for promoting civil rights. So whenever you hear the phrase the Warren Court, they're talking about this era in time when the Supreme Court had Chief Justice Warren as their, supervising Chief Justice. And the way they would promote civil rights is by what some people call substantive due process, what some people call judicial activism. And it's a situation where the Supreme Court, or let's say one judge, would be presented with something morally wrong going on, and then would look at the microscope under the lens and try to find some support, kind of looking at the Constitution under a microscope and trying to find some kind of support to right that wrong. People or traditionalists would say, I'm like a referee, I just call balls and strikes, and or an umpire, call balls and strikes, and I'm not going to interpret anything. Now we can look at some other cases that pertain to schools and the rights of African Americans to receive a fair and equal education according to the mandates of the Equal Protection Clause of the 14th Amendment. And while doing so, we're going to be going a little bit out of chronological order, because after this, I'm going to be talking about some cases from, time periods that might be on the outskirts of this time period. But looking at things topically, first of all, we want to look at what affirmative action is, because in modern times, when we're talking about equality and equal protection in schools, we're not talking about segregated schools anymore. Although, if you look at how segregated schools can be, perhaps we should be. But as far as the Supreme Court cases that are on the record right now, we usually focus on affirmative action. And affirmative action refers to a policy or set of policies that an educational institution might have to ensure diversity within their student body. Some people think that they're the same thing as quotas. And a quota would be if, say, I was president of UMass Amherst and I had some kind of rule or policy that said that 10% of the student body has to be African American or Asian or something like that. That would be a quota, and that is not allowed. So that's sort of a fiction, if you ever heard that. And what also is not allowed is somebody being admitted to an institution solely based on skin color, or somebody admitted to an institution when they have inferior qualifications. So to see how we got to those policies, one of the first cases we can look at is the Bakke case in 1978, the Regents of the University of California versus Bakke. And in the Bakke case, the plaintiff, whose name was Alan Bakke, he was a 35-year-old white man. He applied 2 different times for admission to the University of California Medical School, and he was rejected both times. And the school reserved 16 places in each entering class for 100 quote-unquote qualified minorities as part of the university's affirmative action program. And Bakke's qualifications exceeded those of any of the minority students that had been admitted during the years that his applications were rejected. So the case got brought before the Supreme Court of the United States based on the equal protection guarantees, and keeping in mind that we're using strict scrutiny, right? Because this is a matter where we're talking about race. And the question before the court was, did the University of California violate the 14th Amendment's Equal Protection Clause and the Civil Rights Act of 1964 by having this policy that resulted in repeated rejection of Bakke's application to medical school? Well, the Supreme Court's answer was no and yes. There was no single majority opinion. This is one of those plurality opinions. So 4 of the justices contended that any racial quota system that was supported by a government agency, that it violated the Civil Rights Act of 1964. One of the other justices, Justice Powell, agreed, and he cast the deciding vote that ordered the medical school to admit Mr. Bakke. However, he argued that the rigid use of racial quotas as employed by the school violated the Equal Protection Clause of the 14th Amendment. The remaining 4 justices said that the use of race as a criteria in admissions decision in higher education was constitutionally permissible. Justice Powell joined that opinion as well and contended that the use of race was permissible as one of the several different admission criteria. So this case is known for being somewhat confusing because it wasn't crystal clear. Usually you have a clear majority opinion where you have, even the most contested cases, at least 5 justices signing on to the same opinion and giving you a clear majority opinion. So as far as what you can glean from this, which will be a little bit more clear when we talk about the Fisher case, is that a public institution can have an affirmative action policy, but you cannot have quotas. So for this particular university that had a certain number of slots, regardless of the credentials of those minority students, something like that wouldn't be allowed today. You can't have a strict, quota system or anything like that. What you can do is take race into account as one of many attributes of a student that you can consider for admission. So the way it's supposed to work is that an admissions committee would have 2 students of pretty much equal qualifications, and say, for example, one of them was a lacrosse player and your school needed more people that were athletes and needed somebody on the lacrosse team, that would give them an edge in that instance. Or in another scenario, say 2 people looked equal on paper, and one student was African American, and you looked at the demographics of your incoming class, that might give them an edge for the sake of diversity, which sometimes can be done for reasons of gender also. So the way it's supposed to work is that nobody is admitted solely because of race one way or the other, and that is only considered, race and diversity is only considered one of many qualifications. And we'll see with the Fisher case that sometimes that's in dispute, and it gets very controversial. All right, the next case that we'll talk about that has to do with schools is what's known as the Picks case in 2007. The full name you can see there, the parents involved case. And this had to do with an institution that was not a college. In this particular case, we're talking about K through 12 institutions of learning in Seattle, and they had this set up prior to 2007 where students could apply to any high school in their district, and certain schools were known as the go-to schools. They were probably known as the good schools or the best schools in that particular area, and they had way too many people applying to go there. Way too many students choosing those particular school or schools as their first choice. So the district would use a system of tiebreakers to decide which students could be admitted. And the second most important one was one that pertained to race. It was a racial factor intended to maintain racial diversity. So if the racial demographics of any school's student body deviated more than a certain number of percentage points that were reflective of the student population, then that student could be favored. So in other words, this particular area of Seattle had approximately 40% white students and 60% non-white. And this racial tiebreaker would go into effect if the admitted students were not following in line with the actual demographics of the city or town. So sometimes somebody could be favored for admission if you were white or non-white. It's just depended on which area and in which high school you were talking about. So this nonprofit group, the Parents Involved in Community Schools, PICS, that's their nickname, it's known as the PICS case, they sued the district saying that this racial tiebreaker formula, it violated equal protection and that it also violated the Civil Rights Act of 1964, which we'll look at in a minute. So there was a dismissal in the lower courts. There was a reversal at another Supreme Court level. But when you look at the Supreme Court's precedents on racial classifications, they have to be directed towards a compelling government interest. There has to be strict scrutiny. And the Supreme Court really looked carefully at how the circuit court analyzed things under the constitutional rules in play, and they found that it was not narrowly tailored. And the Supreme Court eventually ruled by a 5-4 vote. That means only 5 justices agreed with what I was about to say, and 4 did not. They applied a strict scrutiny framework and found that this district's racial tiebreaker plan, which basically mandated that these schools that had too many kids wanting to go to them, and that they wanted the entering class to directly reflect the ethnic makeup of the surrounding cities and towns, 40% white, 60% non-white, that scheme was unconstitutional under the Equal Protection Clause. And Justice John Roberts, who was Chief Justice back in 2007 and still is today, said the way to stop discrimination on the basis of race is to stop discriminating on the basis of race. The court acknowledged that enhancing racial diversity is a compelling government interest, that strict scrutiny is something that can be met in certain cases, but it's not when you have a situation like this, or a situation like they had in the Backey case, where things seem to be, mandating some type of formula or mandatory quota or compliance with some predetermined statistical computation. It's just supposed to be part of a holistic goal and just one attribute that you can consider when you're looking at the admitted students to your school district or university or whatever it might be, along with everything else, and trying to prevent some sort of, racial imbalance. But the way the school went about it in this case, did not do it in Seattle. So Parents Involved, the PICS case, as confusing as it was, it was written in a little bit of a confusing way, just like the Backey case was, but it reiterated the fact that you cannot have formulas. You can consider race as part of a larger philosophy and practice to make sure that your student body is diverse, but you can't have anything where you're using math and quotas to put you in line with that goal. Now, the Fisher versus Texas case, it's actually Fisher Part 2, because this case was in front of the court a couple of times. And what we're interested in is the final word of the Supreme Court, when it was in front of the Supreme Court most recently, is what we'll be looking at. And in this case, the University of Texas had a policy where they did use race as a consideration in the admissions process, but it was found not to violate the Equal Protection Clause. And in this case, Abigail Fisher, who was a white female, she applied for admission to the University of Texas, but she was denied. And she actually did not qualify for this thing in Texas they had called the Top 10% Plan, where you were guaranteed admission if you were in the top percent of your high school's graduating class. So in other words, in Texas, you're in the top 10%, you get an automatic admission to your state school. Abigail Fisher wasn't in the top 10% of her class. And for the remaining spots, the university could consider a whole bunch of factors, including race. There was no quota system, nothing like that. And that top 10% thing for high school students, that particular thing had nothing to do with race. So Fisher sued the University of Texas and argued that the use of race as a consideration in the admissions process violated the Equal Protection Clause of the 14th Amendment. And by all accounts, she was talking about, the whole pool of students that were not in that top 10%, like her. So the case ended up going in front of the Supreme Court, and the court had to analyze the policies they had at the University of Texas. And the Supreme Court said it did not violate equal protection guarantees, that any quota system that they had, like that top 10%, had only to do with somebody's high school GPA. It had absolutely nothing to do with a person's race, and that this Abigail Fisher wasn't in the top 10%. She was just applying like all the other regular Joes and Josephines, and that there was no issue of, any evidence of the University of Texas or any other state institutions in Texas of having any kind of special consideration or quotas or numbers or anything to do with having a certain number of African Americans or Asians or anybody else that could be considered a minority by anybody's definition, having a certain number of spots. So a lot of people found it confusing because the case was very long and quoted other lengthy and somewhat complex cases. But in the end, what we can see is that the Supreme Court was somewhat consistent. They said it's fine, just have things be holistic and don't use quotas. There are currently some cases going before the Supreme Court now that have to do with alleged discrimination against Asian Americans at Harvard University. There's been some evidence that Harvard University is being biased against Asian Americans by only, admitting a certain number and denying people who are really qualified that are of Asian descent, because allegedly that would mean, there are too many Asian students going there. So, sorry, I got interrupted there momentarily, but there's going to be a case coming up before the Supreme Court soon. It's already on their docket. They just have to schedule it to be heard. The paperwork's been filed, and it's called the Students for Fair Admissions versus Harvard. And this is where the Asian American students and their representatives will get an answer to whether or not they've proven their case that Harvard admissions is being biased against admitting too many Asian Americans. So it'll be interesting to see the outcome of that. All right, so to look at cases and issues that don't pertain to education, we have to look back at how the state action requirement comes into play when it comes to cases where the Supreme Court is trying to establish the parameters and show how far they're willing to go to protect the rights of African Americans. So we're going to be going out of chronological order because I'm going to be going back to 1948 and the case of Shelley versus Kramer. So the Shelley versus Kramer case involved an American family. You can see the picture right there. Mom and dad, it looks like they had 6 kids. Look very, typical, even down to the teenager who's sitting down, the one with the bow around her neck, who has the look on her face that my son gets when he does not want his picture taken. But in any case, they saved up. They purchased a home for their family to live in, so they didn't have to live in apartments anymore. The problem was, way back in 1911 in St. Louis, Missouri, this particular neighborhood had a racially restrictive covenant designed to protect African Americans and Asian Americans from living in the area. So if you don't know what a restrictive covenant is, without getting too much into the weeds of what all that's about, there's certain documents that are recorded at what's called the Registry of Deeds. Each geographical area in the United States, usually each county, has something called a Registry of Deeds, where the deed to your house gets recorded and other things get recorded there, like copies of zoning laws and other restrictions, like things called restrictive covenants, which are official documents showing restrictions on what things can be built, and it used to be who could live there and things like that. So in 1945, this Shelley family, they moved into the neighborhood, and somebody living by them named Louis Kramer, he brought a lawsuit to enforce the covenant and prevent the Shelleys from moving into their house. And there were similar lawsuits in Detroit, and I think there was another one in DC. And the problem was, as you can remember, that the government can't step in and say, we're going to prohibit this racist situation from going on unless it's a situation, generally speaking, where it's the government doing the discriminating, right? So if, for example, hypothetically, like this would never happen in real life, but say the dad in this family wanted to sign up to be a member of the Ku Klux Klan, one of the most racist organizations in history. If he hypothetically wanted to do that, he wouldn't be able to because they're a private organization and could say, no, you can't be a member of our organization because we're racist and you're African American. So this situation, one could argue that there's nothing the Supreme Court could do because this restrictive covenant has to do with private matters. It's not the government that has this restrictive covenant. It has to do with private ownership of property, which I guess there's a point to that. One could argue, I suppose, but the Supreme Court looked at it a different way. And what they asked themselves was, does the enforcement, because it would be the government having to enforce it, of a racially restrictive covenant violating the Equal Protection Clause of the 14th Amendment. And this was a unanimous decision, and that the Supreme Court said that although these covenants don't violate the 14th Amendment and private parties could write these all they wanted, they're eventually seeking the government's help to make it a reality. So you're asking the Registry of Deeds to record these documents. You're asking a court to enforce it, to, kick a family like the Shelleys off of their property through a lawsuit. And then you may or may not be aware, but say there was a lawsuit either in an apartment or property that you owned where a judge ruled against you and said you had to be removed, it would be up to the local sheriff to physically kick you out and enforce the order. So the Supreme Court said, at the end of the day, this isn't really a private action. It is a state action because the drawing up of these racially motivated documents, that part in theory isn't a state action, but you're asking the courts to enforce it. So no, you can't have restrictive covenants like that, and the Shelleys are going to stay exactly where they are. There was another case that was pretty similar, the Moose Lodge case that came up in 1972, And a lot of people thought that the Supreme Court was going to carry over this philosophy to private entities, but they did not. So in this case, there was a gentleman, Mr. Irvis, who was an African-American gentleman, and he was the guest of a white member of this Moose Lodge 107, and he got refused service at the club's dining room because of his race. I would imagine that the person who invited him was probably horrified and didn't know of the bylaws. But in any case, the bylaws of the lodge limited membership to white male Caucasians. And so Irvis challenged the club's refusal to serve him. And he tried to say, Mr. Irvis, tried to say that this constituted state action, even though Moose Lodge was a private club, because the Pennsylvania Liquor Board issued the liquor license, and so that made it state action. Well, the Supreme Court looked at everything, and in a 6-3 decision, they said that the Moose Lodge could, in fact, refuse to serve food and beverages to Irvis because he was Black, and only because it had nothing to do with any sort of state or government law, rule, or regulation. They said there wasn't enough involvement of the government to make this a state action, and that the mere issuing of a liquor license wasn't enough to make them rule otherwise. So, some people think that those decisions contradict each other. I personally don't, because if you look at Shelley versus Kramer, that has to do with a person's ability to live in a neighborhood where they actually purchased real estate, and, you're asking whether or not the government can actually kick them out of the home that they purchased, which is involving much more government interaction than the Moose Lodge case, where somebody just can't go to one certain, lodge. And as horrible as that rule might be, by today's standards, a business like that would not continue to be able to exist by any means. But at least, back then, they were able to have that rule, as horrible as it was. So bringing us up to current times, you might say, well, considering what the Moose Lodge case said, how come we don't have segregation in hotels and movie theaters and restaurants like you used to see back in old movies or historical documents? The quick answer to that is the certain language in the Constitution and the Civil Rights Act of 1964 did away with that type of segregation and full-blown apartheid that we used to have here in the U.S. So the Commerce Clause refers to Article 1 of the Constitution, Section 8, Clause 3, and it gave Congress the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. So in other words, if you're a hotel, movie theater, restaurant, so on and so forth, you service individuals from different states who are traveling, and Congress has the power to regulate that type of commerce. And your business doesn't just do business within the four corners of the state, so to speak. They do, partake in interstate commerce, so the government can regulate it. And what helps it make a little bit more sense is looking at the actual language of the Civil Rights Act of 1964, which relied on the Commerce Clause as a means of enforcement. So this is considered one of the most important civil rights acts of all time. And Title I of the Act provided for equal voting rights by removing registration requirements and procedures that were biased against minorities. You still have to register to vote, but there were certain procedures left over from the Jim Crow days that they in Congress got rid of. And they also prohibited segregation or discrimination in places of public accommodations that were involved in interstate commerce. And it also banned discrimination by trade unions, schools, employers, anybody who does business with the federal government. And the latter section also applied to discrimination on the basis of sex and gender. And they established the Equal Employment Opportunity Commission to enforce things and make sure those protections were put into place in places of employment also. So places like the Moose Lodge, who are, places like that are very small in scope, could in theory continue to exist. But, in places of public accommodation, movie theaters, hotels, restaurants would not be allowed to have those types of rules. And going forward, the Supreme Court would have to decide things like that on a case-by-case basis. Any private business now that tried to have policies like that would not achieve any sort of broad-based commercial success and would only appeal to, Americans who were involved in hate groups or groups like that. Can you imagine anybody in the year 2022 trying to go to some sort of lodge that had a rule like that? And any existing Moose Lodges around, there aren't very many. They don't have rules like that anymore. So looking forward to other cases that, again, pertain to other areas of life outside of schools and outside of situations where we might have to analyze state action. Remember that when a law creates a classification based on race or natural origin, that the court is going to apply strict scrutiny. The law is going to have to be narrowly tailored to achieve a compelling state interest. And remember, when things have to do with gender, there's going to be this middle ground of intermediate or heightened scrutiny, and all other characteristics, discrimination based on age or something like that would only need a rational basis scrutiny. And that reminder is good to look at when we're looking at some other cases, other historical cases that don't fall into the category of education or state action. If you can believe it, going back to 1967, which is the year that my older sister was born, that was, about 55 years ago. Loving versus Virginia was the landmark historical case that struck down state laws that were banning interracial marriages. Believe it or not, up until 1967, some states, like Virginia, had laws on the books still that prohibited interracial couples from marrying. And the folks in this picture were just typical, boring, everyday people who happened to be an interracial couple. And they did not want to move out of the state of Virginia because that's where their roots were. That's where their family support was. That's the place they called home. So they fought this matter in the courts all the way up to the Supreme Court, and they won. This particular law in Virginia and all other states were stricken down, and the Supreme Court made clear, looking through the lens of equal protection, that you cannot have laws like this that restricted people from marriage based on race. And there is a good movie on Netflix. I've only seen bits and pieces of it, but I think it's old enough now that it's one of the ones you could get on demand for free or on Netflix for free, and it's called Loving. And I think it's worth a watch if that's a topic that interests you. There are a lot of other historical cases we could look at, but just because of us being in a 6-week course, I just want to focus on the most famous and most historical ones. I think the last one we'll talk about is Washington versus Davis, that was decided on in 1976. And this has to do with applications of 2 Black people that were rejected by the District of Columbia Police Department. And the 2 men filed suit against the mayor. And These two Black gentlemen alleged that the department's recruiting procedures, written personnel tests, and other requirements were discriminatory against racial minorities such as themselves. And they claimed that one particular test was unrelated to job performance and had the resulting consequence of excluding a whole bunch of Black applicants. So the Supreme Court had to look at whether or not these particular procedures violated the Equal Protection Clause of the 14th Amendment. And the Supreme Court ruled that the procedures and written personnel tests did not, in fact, constitute racial discrimination. They found that the clause, Equal Protection Clause, was designed to prevent official discrimination on the basis of race, laws, or other official acts, but that the particular procedures did not have discriminatory intent, although some of the wording and language, looking through a current lens, could be deemed discriminatory, but they were racially neutral. And if you were ever to take a deep dive into some of the history of the case, you see that some of the written parts of the test were extremely verbose, wordy, and things like that. So, they're going to take it on a case-by-case basis, they meaning the Supreme Court. So that was another historical case. To look quickly at other marginalized groups, I wish we would have more time to look at these other groups, but again, when I have students for 16 weeks, we do take more time and look at other groups. But you can see that certain protections have been both given and taken away to people who fall into the category of being economically disadvantaged. In other words, people who are poor. You see that the Supreme Court has been willing to uphold certain laws passed by Congress that are intended to provide a social safety net for people who are economically disadvantaged. But in recent years, they have not stepped in as much. And you can see that a lot in recent headlines. As far as undocumented Americans, immigration laws are very complicated. And in fact, it's a specialty area of the law. I've never practiced in this particular area of immigration law because you have to memorize a whole bunch of the U.S. code that pertains to this specific area. But what we've seen lately, and if I'm talking lately, over the past 30 years, is that the Supreme Court is very likely to uphold policies that provide things like a free education, free school lunches, and free social safety net types of benefits for the children of undocumented Americans. However, when it comes to undocumented Americans themselves, we've all been hearing over years the mess that's going on near our borders as far as the processing and due process of people who are seeking to emigrate here and who do not have valid travel visas or citizenship documentation or anything like that. So for people who are already here and living here, and if we're looking at their children, there is a social safety net for them. It is certainly not perfect, but at least there is one on paper. And for people who have not yet crossed the border, a lot of people who are involved in civil rights would say that there needs to be more due process for people who are being held in conditions that many would describe as inhumane. If the topic of looking at the history of Latinos or Hispanic Americans and their treatment in the United States over the years, there are tons of resources you can get for free on Netflix and YouTube that tell about the Chicano movement, over the years in the history of the United States. There were different phases of this in the early 1900s and in the early 60s in cities and towns all across the United States, mostly in the southwest part of the United States, but it's very interesting to look at. And that gave rise to La Raza, which was a civil rights movement that happened subsequently to the Chicano movement. La Raza eventually became Unidos US, and if you want to look on their website, you can see a whole bunch of the history of this movement. If you just Google Unidos US, it's the first result you'll see. And it's something that's pretty interesting because the civil rights movement of African Americans gets documented really well in the history books. And you don't see as much about La Raza and Unidos US. And I apologize, my attempts at a Spanish accent aren't very good, but I do try. Discrimination against Asian Americans has been making headlines in recent years because for some reason people will blame a random Asian American person walking down the street for COVID when that particular person had no connection with causing the coronavirus to exist here in the U.S. So we've seen some recent backlash and discrimination and even hate crimes against Asian Americans. A very surprising Supreme Court case that I found surprises a lot of students when we examined World War II is the Korematsu versus United States case, which was in 1944. I will have to fix that typo where it says 1994. And that was the case where our Supreme Court approved of the internment camps for Japanese Americans. If you remember back studying World War II, Japanese Americans were put into internment camps in California. And then Native Americans, there was outright, genocide against Native Americans, and we are living on stolen land. If that topic is of interest to you, there's a link there that gives you a good sort of American History 101 as it pertains to Native Americans. I actually put 2 links there if it's a topic of interest. So it's not my intention when we're looking at constitutional law and equal protection to only focus on one group. African Americans, certainly these other groups were affected too. The economically disadvantaged, people who are still undocumented, people who are Latino, Hispanic, Asian, and Native American. But for sake of time, I did have to pick one group to focus on, and I did choose African Americans because of the history of slavery and issues that continue through to today that pertain to the criminal justice system. So please click on any of those links to learn more about any of those groups. And if you wanted to have other resources, certainly touch base with me, and I can give you some great resources for those topics. All right, so transitioning to the rights of the criminally accused. I have to fix that other typo. It's going to drive me nuts. Again, there is a reason why I put this together with the topic of racial discrimination against African Americans. The practical reason is that I have to cover more than one thing each week since it's a 6-week course. But the other is based more on theory and constitutional realities, that sometimes these topics end up going hand in hand, unfortunately. And I'm not one of these people who thinks that, in current day situations that every single police officer is racist. However, I do think that there are some issues with both historical police practices and current day police practices that are extremely concerning. So there is a theory that policing itself, the whole invention of modern police forces as we know them, was born out of the desire to find loopholes around the fact that slavery had been banned. In other words, some people think that white plantation owners realized how much money, that they were going to be out because of slavery ended, and that they were looking carefully at the 13th Amendment and finding a loophole in it. So if you look at the language of the 13th Amendment, it does say neither slavery nor involuntary servitude, except as a punishment for crime, whereof the party shall have been duly convicted, shall exist within the United States. So, in other words, you can make people do hard labor for no money if they are incarcerated, and that's not considered slavery or a violation of the 13th Amendment. There's a movie called 13th. It's free on Netflix. It is a very political movie. It's definitely to, give a message about what the filmmakers believe is at the root of the criminal justice system. It's not just an informative movie, it's a persuasive movie. But it's good to watch if this topic interests you. And it goes back and looks at the history of places like Angola State Prison, which their real name is Louisiana State Prison, and places that were referred to, and some of them still are, as plantation prisons. And if you look over on the right-hand side, that picture, that's from 2015 of incarcerated individuals working, tending crops on a place that was a plantation. Almost all of the inmates at Angola, Louisiana State Prison are African Americans, and they do, work on a plantation for little to no money. So that's sort of one of the more shocking examples. If you look back at the history of what police departments used to do when they were on patrol back in the early days, there's a lot of persuasive historical evidence showing that they were really over-policing neighborhoods where a lot of African Americans lived and arresting them for petty charges like vagrancy because they were sitting for more than 15 minutes in front of a building. So looking at that through a more modern lens, you don't have a lot of plantation prisons now, but what you do have are a lot of prisons where the inmates perform some type of factory labor for little to no money, especially private prisons that aren't part of the government, that are just contracting with the government. And then they also have other contracts where they're producing, a product for private industry. And a lot of people see that connection with the over-policing of inner cities now. So this might be, a theory that you agree with or don't agree with. I don't think it's either one or the other. That, I don't think absolutely everything to do with policing and incarceration has to do with, the entire system trying to find a loophole and incarcerating and imprisoning people. But I think that it definitely was part of the motivation for post-Civil War structurally formalizing a nationwide police department. I think a very motivating element of that was financial, especially when you see places like the Angola prison and other plantation prisons. So do I think it was the only reason? No. Do I think it was one huge, important motivating factor? Yes, certainly. And it's, it's clear the UCR and other statistical bases show that, inner city neighborhoods are policed much more frequently than other areas. So in any case, the part we're going to look at today is just the basic amendments that are involved when you're talking about the rights of the criminally accused, and just the part of the process that refers to warrants, investigations, and arrests. Next week, we'll be looking at, things that have to do with attorneys and trials and incarceration and stuff like that. So the amendments you focus on when you're looking at the rights of the criminally accused are the 4th, 5th, 6th, and 8th Amendments, plus the due process clauses of both the Fifth and the 14th Amendments. So when you look at the language of the Fourth Amendment, which you can read right there in very old-fashioned language, which is not the way we tend to speak or write nowadays, this has to do with search warrants and searches and seizures and arrests, which I'll go into more detail with later. But basically, the general rule is that the police are supposed to have a warrant that's supported by probable cause in order to search you, your person, your home, anything like that, or, that you gave them permission. And that any type of warrant is supposed to be supported by probable cause. And we'll get into the details of, talking about what that's all about. The Fifth Amendment, most people know what pleading the Fifth is. It's your right not to incriminate yourself. But it also has to do with your right to have a grand jury decide if there's enough proof to charge you with a felony in federal court. So in other words, it's sort of like a screening process. A grand jury isn't like a regular jury. They don't decide whether you're guilty or not guilty in court. It's 23 people who decide if a prosecutor has enough proof to even charge you with a felony, whether it's more likely or not that you committed this felony in federal court. And a lot of states give you grand jury rights too. So it's just an additional screening process and guarantee of civil liberties if, the police can't just stick a felony on you without it going through some of your fellow citizens first. Truth be told, grand juries almost always decide to indict. That's the formal word, indict, decide to charge you with a felony. The Fifth Amendment also contains the double jeopardy clause. So you can't be charged with the same crime twice. You also can't be compelled to be a witness against yourself or be deprived of life, liberty, or property without due process. Basically, that means that you need fair treatment in court, that the government went through every single step it was supposed to from the time you were arrested to the time it went through court, your sentencing, all that. And then, nor shall private property be taken for public use without just compensation. And we won't get into that much. That just means if they wanted to build a highway like right through where your house is, that the government would have to pay you fair market value for the house, which doesn't always happen. The other amendments, the Sixth Amendment is all of your trial rights. So you are entitled to a speedy trial, a public trial, an impartial jury in a predetermined district that's near where you live. You're supposed to be informed of the nature and cause of your accusation. You're supposed to be confronted with the witnesses against you. In other words, they have to come to court and testify so your attorney can cross-examine them. They can't just send in an affidavit or sworn statement to court. You have the right to compulsory process, which is the right to call your own witnesses and subpoena people into court. You have the right to effective assistance of counsel. In other words, you have the right to get an attorney to represent you for any charge that could possibly put you in jail if you can't afford one. And then the Eighth Amendment, excessive bail is prohibited. Same thing with excessive fines, and same thing with cruel and unusual punishments. Although we do have the death penalty, states can decide if you have the death penalty. So, and at all times, the government has to abide by due process. So what does that mean if we're looking at the beginning parts of a criminal case, the investigation and arrest and getting warrants and all that stuff? Well, first, what is probable cause? Probable cause is when a police officer determines it's more likely than not, 51% or more certain that a crime has been committed. And that's decided on a case-by-case basis. Warrants are legal documents that give permission for a police officer to arrest somebody or to search their home or property or their person. The officer has to sign a statement under oath that establishes probable cause and get it approved by a judge or a magistrate. And the warrant has to state the places to be searched and the things to be seized. There are plenty of exceptions to the warrant requirement. The police don't always need a warrant. What if you want to give them permission? If you want to give them consent, then they don't need a warrant. And there's about a dozen other exceptions, like if the police were in hot pursuit or if they saw something in plain view. So there's about a dozen exceptions that we won't have time to get into all of them, but we'll cover a few next week. So some of the landmark cases when we're looking at this beginning stage, this part one of the rights of the criminally accused, a good starting point is to look at Mapp versus Ohio in 1961. And this was the first time that the Supreme Court had to answer the question about, what do they do if the police raided somebody's house and searched through all of somebody's belongings and they didn't have a search warrant and there was no exception to the warrant requirement, right? There wasn't a situation that was an emergency. They weren't in hot pursuit of anybody. There was no plain view situation. So the Supreme Court, for the first time in 1961, established this exclusionary rule. And what this exclusionary rule means is that if the defense proves in court that law enforcement obtained evidence in violation of the Constitution, there was no warrant, there was no consent, there was no exception, there was no emergency situation, then that evidence is taken out of the case. And that usually means the whole case is dismissed, because how do you pursue a case with no evidence? Sometimes you can without that particular piece of evidence that got excluded. Like, say there was a murder and a bloody glove got excluded from the trial, but there was a witness to the murder, right? But most of the time it's not like that, and the whole case gets dismissed. Well, how does it get dismissed? What the defense attorney does is they file a motion to suppress. All a motion is a written request to the court, and a motion to suppress is a specific type of motion where the defense attorney says, look, according to Mapp versus Ohio, hey, court, you're supposed to apply this exclusionary rule and take this piece of evidence out of the case. So a lot of people refer this to a defendant getting off on a technicality. That's sort of a slang way it's referred to. It basically, it's the police did something they weren't supposed to do. They did something unconstitutional. And the issue of whether or not the defendant did the crime, that's not the focus. It's the constitutional issue. And most of the time, the whole case gets dismissed. So not everybody agrees with the exclusionary rule, but it is a historical and very important case. A few years later, the Miranda versus Arizona case was decided, and most people know about that. That was the famous case that occurred in Arizona with Ernesto Miranda, who was accused of a horrible crime against a young female. And there was a confession, and the Supreme Court was putting that confession under a microscope because there was allegations that it wasn't a knowing and voluntary confession. Back in the olden days, people could be roughed up. There could be situations of forced confessions. There could even be situations where somebody was manipulated because they weren't educated or had an inferior intellect or something like that. So most of us know, this is one of the few times where TV and movies get it right. The warnings that have to be given to somebody when they're getting arrested are, you have the right to remain silent. Anything you say can and will be held against you in a court of law. You have the right to an attorney. If you can't afford an attorney, one will be provided to you. And do you understand these warnings that I have just given you? And then the person has to answer yes. In real life, there's usually, a thing that the defendant will or suspect will sign and check off too. So there's no doubt about the warnings being given. But this was the first time that these warnings were formally required in 1966. One thing that people sometimes don't realize is, technically speaking, in order for somebody to be entitled to Miranda warnings, they're supposed to be in custody and being interrogated. So in other words, if you're not in custody and a police officer is just asking you a bunch of questions and you're free to leave, technically you're not constitutionally entitled to Miranda warnings. Or if you're in custody and you're just riding in the back of the cruiser and nobody's asking you questions, nobody's interrogating you, technically you're not entitled to Miranda warnings. Realistically, every police department tells every recruit and officer to just Mirandize everybody, even, walking down the sidewalk, because they don't ever want to have to deal with the issue. And in real life interrogation situations, when somebody's in a room being questioned, it's videotaped. They repeat the Miranda warnings. They have them repeat them on the video, look into the camera, sign a form, the whole 9 yards. But technically, you're supposed to be in custody and be being interrogated for those to apply. Another important case is the Terry versus Ohio case that was decided in 1968. And this was remarkable for two huge reasons. So, just a little bit of background. Sometimes the police might have to, for public safety reasons, walk up to somebody and engage in what's called a threshold inquiry. That's a beginning conversation where a police officer thinks something is up, that the person is about to do something that could hurt somebody or themselves, and they want to engage in a conversation to find out what's going on, because, realistically, we shouldn't have to wait until somebody gets hurt before the police can step in. So a perfect example would be if the police saw people walking back and forth outside a convenience store when it was about to close, and it looks like they're about to hold up or mug the store owner as they exited the building, the store, after it closed down. If the police were witnessing two people, what they call casing a place, they were looking all around and had something in their hand that was like a weapon, and they're looking at the door around closing time, waiting for the person to come out. I think most people would agree they shouldn't have to sit back and wait till somebody gets smacked over the head with something or stabbed or shot before they can walk up and ask people what's going on. So where do you draw the line? So for a long time, even before Terry versus Ohio, police had engaged in a practice called a pat down or a stop and frisk, also known as a Terry stop. And this is something that would happen when the police would go up to somebody who looks like they're about to do something really bad. They would ask them what's going on. And if the situation still seemed suspect, they could literally pat down the person with their hands, the outside of their body, looking for weapons to see if they felt a gun or a knife or something that could hurt somebody. And then if they did, they could remove that harmful item and then ask the person if they had, a permit for the gun and what's going on with that. So there has to be some kind of parameters for that. So Terry versus Ohio referred to one of those cases where the police went up to somebody and did one of these threshold inquiries and started to do a pat down or a stop and frisk or a Terry stop. It's the same thing, known by 3 different names. And the Supreme Court said, yes, you can do that, but only if you have this level of proof called reasonable suspicion. And it was this new, unique level of proof. And it's something of a unique thing. It certainly is not just a hunch. The police can't just go up to somebody and start patting them down because they just have this funny feeling in their stomach. Maybe the hairs raising up in their arms that makes them think something's going on. The police technically aren't supposed to do anything based on just a hunch. But probable cause is when you're 51% or more sure of something. So the Supreme Court actually established this new thing called reasonable suspicion that is more than a hunch, but it's less than a probable cause. And this occurs when the police can logically articulate a reason for their suspicions, something that is a legitimate, observable thing. So, for example, if I was a police officer testifying in court after a defense attorney filed a motion to suppress, and I was trying to prove that I had reasonable suspicion after I saw somebody casing a convenience store and about to rob the store owner, I would talk about how I kept seeing them look at their watch or their phone to see what time it was, how they were pacing back and forth, how I saw a weapon in their hand, all of those things. And if I was believed and there was some sort of surveillance backup, certainly that evidence would not be suppressed, and the judge would think that there was a reasonable suspicion, because that's a situation where there's definitely more than a hunch, but there's not quite probable cause. Like, it's not more likely than not that those people were going to rob that place, but it was definitely more than a hunch. So those are the two new things that were sort of really earth-shattering with Terry versus Ohio, that pat downs or stop and frisks and Terry stops are constitutionally permissible, but you have to abide by this new level of proof called reasonable suspicion, where there's no one-size-fits-all description. It's decided on a case-by-case basis, but it is more than a hunch. It is less than 51% sure, and I've seen these go through hearings in court dozens and dozens and dozens of times. And if the police are spelling out a situation and their testimony is believed where it looks like somebody was casing someplace and ready to rob it, or looking like they were about to break into a car or about to mug a person walking down the street, and they're spelling out things that apply to a person's common sense, things a person does when they're getting ready to rob somebody, the evidence isn't going to be suppressed. The problem is, in later years, there's been a lot of controversy about these Terry stops being done at free random in certain high crime cities and only being used on people of color, when the people were just, existing and walking down the street and being black. So there was a lot of controversy in certain cities, especially over the past 5 to 7 years. And those headlines kind of started going away around the time of the pandemic. So we'll see if those headlines emerge again. There's been a lot of police reform in a lot of cities and towns where some of the best practices guidelines are to really scale down the frequency of these pat downs. The final thing I want to tell you about are some new-ish cases about this part one of the rights of the criminally accused. The United States versus Jones case came about in 2011, and that was a case where the police were investigating a certain individual, Mr. Jones, as being a suspect for certain crimes. And without a warrant, they put a tracker on his car. And when it went before the Supreme Court said you can't do that. If you want to put a tracker on somebody's car, you have to get a warrant first. Once you get a warrant, that's fine, but you can't do it without a warrant. In 2013, there was a case called Florida versus Jardines, which hopefully I'm saying the right way. That came about in 2013. And that case and the Rodriguez case both had to do with police dogs. Police dogs are considered a law enforcement tool. And in the first case, the 2013 Florida case, the question was addressed about, well, what if you have a police dog and you have no warrant, and the dog is sniffing the area right around outside someone's home, the perimeter directly around somebody's home and their front porch, which is also known as the curtilage of somebody's home. And then the police dog gives you a hit. They give their signal to their handler, like, hey, I smell drugs or whatever other illegal thing they're trained to smell. Can the police then say, okay, this is an exception to the warrant requirement. I don't have a warrant, but my police dog just gave me a hit and signaled me. The Supreme Court said, no, you can't go onto somebody's property in their yard, specifically the area that constitutes the curtilage of the home, and then say, oh, I don't need a warrant because the police dog gave me a signal that there are drugs here. What you could do is apply for a warrant and then have you, work with your dog to lead you to the evidence. The Rodriguez case that came about a couple years later was a situation where the Supreme Court had to say, well, let's look at situations that have to do with automobiles, right? What if a dog smells the car of somebody who's pulled over on the side of the road for a traffic stop, and then they're giving you a hit, and there's no warrant? The Supreme Court said, that's okay. That's fine because of, there's lesser of an expectation of privacy when you have a vehicle on the side of the road. It's not the same as your house. So some people thought those two were conflicting decisions, but they're really not, because, the Florida case showed that your home is your castle, it's your sanctuary, and cars, people really don't have as much of an expectation of privacy. The most recent case in this particular area that was decided in 2022, the Vega case, had to do with a citizen who wanted to be able to sue a police officer in civil court. This isn't the criminal case. This is a civil court, a lawsuit for money, because at the end of the day, it was proven that this person didn't get Miranda warnings. And the Supreme Court decided no. Things might happen in court, in criminal courts with a motion to suppress. Maybe that confession won't be allowed to be used in the criminal case. But regardless of what goes on in the criminal courts, you can't sit there after the criminal case has gone through the system and say, look, I have proof that my Miranda rights were violated and I'm going to sue for that. So we have had a lot of criminal justice reform. We've had a new police reform bill decided here in Massachusetts that I'll tell you about next week. But that doesn't give people standing to sue in civil court. So last but not least, wrap up and looking forward, because I know this week's video was somewhat long. This week we looked at warrants, amendments, investigations, and arrests. And next week we'll look at attorneys, trials, evidence, and voting/representation. So don't forget to get started on your individual project so you're not leaving it to the last minute. And now you can go on to your discussion board and your weekly quiz. I will talk to you next week.